Hello, I am Tabitha Kielholtz, the Director of Special Education for District 70. This video, I hope, will give you a little background of special education, and at the end I'm going to give you some resources that you might find helpful for your family to continue to be educated and know where to find the appropriate help online. We're going to start with the history of special education. We're going to start right from the beginning. Special education was, or education in general, was, the founding fathers decided that that was not a federal, it was not going to be regulated by the federal government. Rather, it was going to be regulated by states, per state. So, we're going to see how the federal government gets involved a little bit later on, but to start us off, the states each were in charge of education, okay? So the 10th Amendment is where we find that. So the first case that I would like to talk about is Watson versus the City of Cambridge in 1893. This is very important to start here. It was believed that students that had disabilities couldn't learn like the other students. If they couldn't talk well, then they were just lesser than the other students. They felt that they were disruptive. If they had Tourette's or if they, would just blurt out, they did not want them disrupting the regular students. So they could expel these students if they came in and gave any sort of problem. So that's where we start with that they couldn't be in school or they needed to be in an institution because they were different. And so the only kids in the schools were normal kids. So then in 1910, there was the first White House conference where the main goal of this conference was to get programs for kids with disabilities. So they were successful in doing this. So what they have done now in 1910 is they took students that were in these institutions because they were different, and they said that's fine. They can come into the schools, but we're going to put them in special classes and special classrooms. So they went from the children being in isolation in these institutions. Now they're going into segregation because they are in the schools, but they can't be with anybody else because, of course, again, they're going to be a disruption, and the other kids can't learn if they are around the kids that have special needs and disabilities. So at this point, compulsory laws were in place, but children with disabilities were often excluded from public school. The states made statutes that gave the school the right to exclude kids with disabilities. So in 1934, the case that we're going to talk about now is a case that came out of the Court of Appeals in Ohio, and they ruled that statutes regarding the compulsory attendance for children ages 6 through 18 gave the Department of Education the right to exclude certain students. So again, we're making these laws and talking about how the attendance works, but it still excludes students with special needs. 1930 to 1940, parents started having enough. Parents of these special needs children had enough, and they started banding together for inclusion for their children in the public schools. There was some victory for these parents, and they were able to get a classroom for the kids, but it had to be taught by the parents were doing a lot of the teaching. So then from this movement from the 1930s to the 1940s, advocacy groups started forming through these parent protests. Groups such as the National Association for Retarded Children, the Council for Exceptional Children, and the Association for Persons with Severe Handicaps. Those all came out of these protests by the parents. And then we're going to move on to 1954 Brown versus the Board of Education, which is a very common case that a lot of people know about. That brought up some equal protection. It was an equal protection movement in which the high courts ruled it unconstitutional to segregate based on unalterable characteristics. That was a huge breakthrough for the special education population. So we start to see a breakthrough. In 1971, the Pennsylvania Association for Retarded Children, they had a class action lawsuit against the Commonwealth of Pennsylvania. The resolution of this case was that all children ages 6 through 21 would be provided a public education that was equal to children that did not have a disability. So this is a huge breakthrough that we're starting to see starting 1954 with Brown versus the Board of Education. Now we're in 1971. We're starting to see some forward progress here. In 1986, the Education of Handicap Amendments, Congress acknowledged the need for early intervention for handicapped children. So we have made a big step now that we are acknowledging that now we need even earlier interventions before they even hit kindergarten. We need to be getting involved with these kids. In 1997, the IDEA amendments sought to have improvements to special education through students' improvements. So they needed to see these students grow in their academics. They needed to see that they were meeting certain goals. And so that's a big deal, not to just think that, well, they're just here to do whatever. No, they're actually here to meet goals, and we're making sure that they're going to meet their goals. In 2002, President Bush introduced the President Commission of Excellence in Special Education, which is another huge step. You can see from the 1800s to 2000s how far that we came in special education, and we're still making strides. We have students in the classrooms now, and we are getting specialists working with the students in the classrooms. There's a lot of room to grow, but we have definitely come a long way. Two quick court cases that I wanted to go over was Forest Grove School District versus TA, and this represents the Supreme Court's decision in IDEA for services for students in private schools that cannot get a public education to offer students with special needs. So in a private school setting, students can go to a private school that have special needs. And in this particular case, they were saying that they cannot get any services to a student with special needs. And what they found is in the Andrew versus Douglas County School District in 2017, the Supreme Court then clarified what a free and appropriate education is. And they told them that you are in a private school, but you will be able to be reimbursed. So in the Forest Grove School District, they had talked about that they're in a private school and they need services. And in some states, and Minnesota is one of those states, you can get services from your public school. And so in the Douglas County School District case that we're talking about, the 1997 amendment to IDEA doesn't always protect private school students the same. So in this case, they ruled that the parents can, through IDEA, are going to get reimbursed for private services that they needed for their child in private education because the public school would not offer that. So when you're talking about private education and you're talking about some of these charter schools, there are different regulations that you are going to find. But IDEA does support, as you saw in these court cases, private specialized help, or resources. So 3 resources that I want to leave you with are the State of Colorado resources, and I'm going to have links all on the website for these. That way you can find the additional help that we have throughout this state. Resources for parents. This is just ways of, this is talking about raising special needs kids and kind of gives you encouragement, gives you some more information. Another one is exceptional student services, and this is a special education page through the federal government. And so all three of those are amazing resources, and I encourage you to look further using those. If you have any questions, please feel free to email me. My email address is also below the link. I hope you found this informative and learned a little bit more and can appreciate the amazing strides that have been made in special education. Thank you so much.